when do you take a case to court? What are the criteria of when you would recommend to take the case to court? And so let me go into those criteria. And remember, you will know more than the attorney. You would think the attorney knows. No, because the attorney doesn't know the intricacies of the medicals. You're the one that should know, and you're the one that should guide the attorney on the strength of the case, okay? And that's what I did. So, and that's tremendously valuable. So, and if you recall, I say, I never lost a case in court. Well, one of the reasons I never lost a case in court is I knew when not to go to court. So let me share with you the categories of when to take a case of court, or when to recommend to your attorney to take a case of court, or what's the strength of the case, okay? So let's look at the strength of the case from the medical perspective, okay? So one is mechanism of injury. The mechanism of injury shows the cause and effect relationship. So that's very important. So the clearer the mechanism of injury, the better, okay? Number two, injury magnifiers. Do you need injury magnifiers to increase the strength of the case or to take it to court? The answer is no. No, you don't. You don't need any injury magnifiers at all, okay? Most cases do have injury magnifiers. I found they have anywhere from 2 to 4. Most low impact soft tissue spinal injuries, I found from practicing, have 2 to 4, and that they become significant and help support the case is what happens. But do you need them? No. 3, subjective findings. Do you need subjective findings at MMI? Well, you don't need them, but yeah, it's pretty important that the person has some subjective findings if you're going to go to court. But you don't need subjective findings. Remember, a lot of people have cancer and don't even know they have cancer. Does that mean they don't have cancer? No. It just means they don't have the symptoms from cancer. That's all. So it obviously is better if the person does have symptoms. And I'm talking about an MMI. And it helps if the patient has, now this is where we get back to the categories that I was talking about. These are the important categories, which is higher low sensitivity testing, higher low probability, primary, secondary, or relevance. Those are some of the categories we're going to pay attention to. So what's important here is, do I have what I would call primary subjective findings? Are they relevant? Are they relevant to that injury? See, if the major problem was the neck, and they don't really have any problems with the foot, the foot's not going to help me a whole lot. I want symptoms relative to the neck if that's where all my findings are. And that's more of primary related. So when I say primary related, there's neck pain, headaches, and other things directly related to the neck. Those are primary. So does it help to have? Do I need it? No. Do I definitely want it? Yeah. And I want them that are totally related. I want them related. And I want it obviously related. And it helps if there's more than 2. But a lot of times you don't. A lot of times the only symptom at MMI is pain. That's it. Okay, so next, same with hybrid findings. Hybrid findings are important. So again, what do we want with do we want hybrid findings? Yes. Yes, we do. And when we do have hybrid findings, I want that box checked. And I want primary findings. In other words, that test shows you have that problem. That's a primary finding, okay? And it's specifically relevant to that injury. See, those are all primary. If I have secondary findings, that's good. So the more primary findings that I have, the better. And the more secondary findings I have, the better, okay? But if I just have one primary finding in the hybrid category, I'm okay with that. I've got it checked. As long as it's primary. In other words, it specifically is positive for that specific anatomy, that was injured and that specific mechanism of injury, see? In other words, it's a clear linear thought process, because this is how it's got to come across to a jury. Okay, so I'd like more. Same with objective findings. Do I need objective findings? You do. Are you going to go to court What's the chances of going to court without having any objective findings and having any success at all? It's slim to none. All of these, the anchor of subjective, hybrid, and objective is objective. You've got to have your objective findings for that low impact soft tissue spinal injury. You got to be really good at it. You got to look for them. You got to get them. You got to find them. You got to document them. You got to quantify them. Now, obviously, and we talk about this, that we have what are called 14 potential. There's all kinds of, findings you could have, but what are the ones that have higher probability? Well, there's 14 high probable objective findings. 7 are primary, 7 are secondary. So we definitely want this category checked, and we definitely at least want one primary finding. Now, it helps if you have a secondary finding. As an example here, if you had altered intersegmental motion plus altered cervical spinal rotation. Those are 2 primary. They're specific to that mechanism of injury and that anatomy. And it helps if you have secondary, such as abnormal physiological line of stress or cervical lordosis. See, now it really helps your case if you have 2 primary and 1 or 2 secondary, plus you have a primary or a secondary in the hybrid and a primary in the subjective, and maybe one or two injury magnifiers, and you got your mechanism of injury. See, this is how. But what's the very first thing that you want? You want all of these boxes checked. That's the first thing you want to go, do I want to go to court with this? Because if I don't have all of these boxes checked, at least in one category, then chances are it's not going to be a good case to take to court or to ask for a policy limit award. So let's see. So the next, after objective, you got complicating factors. Is that important on whether or not you go to court? No. See, so all of these do not carry the same amount of weight. Would I like to have complicating factors? Yes. Do I need it? No. If I do have complicating factors, again, would I like to have primary, at least one or more primary? Yeah, at least one. What would be another complicating factor here? If you had 2, that'd be good. If you had secondary that weren't as relevant. Okay, so complicating factors. So not as important of a category, though, as objective. I could totally do without that. That wouldn't have as much of an impact at all on the case. See? Next is impairment. Well, how important is impairment? Well, that's huge. That's, again, huge. You talk about objective and impairment, that's huge. So you gotta know how to give the impairment ratings from the diagnostics that you did in the objective category. You've just got to be a black belt in impairment ratings for those 7 categories. Now, that's impairment, because remember, the 1-2 punch of personal injury was there impairment, or it just doesn't carry the value? Remember, if there's no impairment, because remember, there's 4 potential injury awards: medicals, impairment, pain and suffering, and prognosis. So if there's no impairment, you've removed one of the 4 injury awards, and if you removed impairment, you automatically removed prognosis and need for future care. So that's not going to be something that you're going to want to go to court with. Which now comes to the last category, which is ADLs. Remember, everything is about how did that injury cause pain or restrictions with activities of daily living. And remember, some activities of daily living are more important than others. As an example, working is very important for somebody that's the breadwinner of a family. Not as important if they're a homemaker and they're not the breadwinner, see? Now that becomes secondary, not primary. If they're not needed for all the core purchases of the family, mortgage, food, utilities, see? Now it becomes secondary, see? But basically you're talking about work, sleep, bathing, showering, getting dressed, clothing, Those are the big ones with the ADLs. So is that important to take do you need it to take a case to court? Well, you don't need it, but you don't want to go to court without ADL restrictions. I mean, you just don't want to do it. It's not going to be much of a case. So again, when we do ADLs, what do we want to pay attention? We not only want this box checked, what do we want? We want primary ADL. ADLs, what's most specific to that person? Let's say that person, makes a living surfing. And that particular injury, they can't surf anymore. Well, that's a huge deal to that person and that injury. Well, let's say the person just casually surfed, once or twice or 3 times a year on the side. And now they can't. No big deal. See, that's what I mean when I say primary versus secondary. What's the relevance of it in the big picture of things? So we not only want ADLs, we want primary, we want, in other words, things that are really important to that person: work, sleep, bathing, showering, getting dressed. Those are the big ones. And then it's good if you have more than one, if they have pain restrictions in more than one. And remember, if they totally can't do a maneuver, that's more valuable than if they can do the maneuver but they have pain and restrictions. See, those are 2 different values. That's loss of enjoyment of lifetime activities versus duties under duress. So whether you can do it or not becomes more valuable. Whether it's primary or secondary becomes more valuable if it's primary versus secondary. An example is mowing the lawn versus not being able to sleep. Well, not being able to sleep is primary. Mowing the lawn's not, see, for the average person. That would be secondary, okay? Unless they did it for a living. Now mowing the lawn just became primary, see? That's how you got to think of these things. So not only do we want the ADLs that have restrictions that totally eliminate the ADL where they can't do, but they have pain and discomfort with the ADLs, and we want primary ADLs relative to them. We'd like more primary ADLs, and we'd like secondary, and the more secondary, the better also. That's what creates the case, the value of the case. But as a bare minimum, I want mechanism of injury: subjective, hybrid, objective, impairment, ADLs. So we're talking about 1, 2, 3, 4, 5. You're kind of talking about 6 categories. 6 categories are vital. They have documentation in 6 categories to ask for a policy limit award or go to court. Was there a mechanism of injury? Was there primary subjective findings at MMI? Okay. Primary hybrid, was there at least one primary finding at hybrid? At least one primary objective finding that gave you the impairment, and at least one primary ADL. So you see, that would be the absolute bare minimum of evidence documentation you'd want to go to court. This is a minimum. So when I had the case that did not have this as a minimum, in other words, I showed the attorney this. This is what determines the value of the case. This is what's going to go into your narrative report, a deposition, or court. Okay? And this is how I educated him to make the decision, but he didn't know how to make the decision because he's not the doctor. So I put this together, explained it to him, and showed him if I had these. So as a bare minimum, I'd have these 6 categories checked in primary. It'd be nicer if I had 1 or 2 primaries and even a secondary in those 6 categories. And it'd be nicer if I also had injury magnifiers and complicating factors, primary and secondary. You see, that's what I'm looking for. That's what's going to determine the value of the case. How much you ask for, and by the way, how much you ask for, that's a total different formula, because the formula for medicals is specific. There's formulas for getting medicals. There's formulas for pain and for impairment. There's formulas for pain and suffering, and then there's money conversion formulas for prognosis and need for future care. So you got to know those. I mean, the last attorney that I just hired me as an expert witness, he asked me, what should I ask for this case? He didn't know. See, so I had to explain all this to him. I said, you've got this. I told him, I go, you got a great case. He goes, why is it? I had to explain. You got all of these categories, and you got primary and secondary, and you have multiple primary and secondary in some of these categories. This is why you have a good case. I wouldn't settle with anything less than a policy limit award. If not, take them to court and go get it. So that's what does it. And you need to be able to explain that to the attorney. And of course, we know the four. And then I had to explain to him, okay, so that's what gave it the case. And then you go, okay, how much you ask for? You go, well, we know how to convert money for medicals, pain and suffering, impairment, and the prognosis and need for future care. So we know how to convert that. So this is the documentation. Add that to how to convert the 4 potential injury awards. That's what gives you whether you have a good case or not, or you shouldn't even be going to court. You should just settle. And in a lot of cases, the attorney should just settle. And there's nothing wrong with you telling the attorney to just settle. Matter of fact, that's not going to hurt your referral relationship. That's going to increase it it's not going to increase it if you just tell them, you need to settle and you don't educate them. You better take them through educational sales like what we're doing here and go, well, these are the categories that determine the quality of the case, whether we have primary and secondary and how many of each of these categories and whether you do or don't have them relative to that case. See, now you just created tremendous value, and that's the attorney who wants you because he knows you won't make him look like a fool and waste time or money either. But he also knows you're the one that's going to get him to the promised land and stop all the lack of lowball offer type situations. See, that I can't impress upon you enough. That is what needs to be delivered. That is the message they have to have, that you know how to put the whole case together to take them to a policy limit award. You know what causes and know how to stop high lowball offers. And you have the logic in between, but you also have the discernment. You know whether or not you have a case or not. And so just flat out explain, you do or don't have that in each of these categories. That's what gets you referrals. They've got nowhere else to go. The chiropractor that knows how to explain that is the chiropractor that gets all their business.